we're gonna be at ease here. We're gonna be at ease here just for a few minutes. Chairman Powell. scheduled meeting of the Public Safety and Homeland Security Committee to order at this time. If we could get Chairman Jaspers and Chairman Powell in their seats, we'd go ahead and start. Thank you very much. I'm going to ask Representative Jackson, if he would, to lead us in a word of prayer as we begin the proceedings here today.
Thank you, Mr. Chairman. Dear Heavenly Father, as we come before you, we ask for your wisdom, your guidance, your leading as we do the business of this great state of Georgia. And Father, we ask for peace in the Ukraine. Let the people sleep in peace tonight, every man, woman, boy, and girl. In Jesus' name, amen.
Amen. All right. We have several bills here on our agenda today, and what I hope will be the final Public Safety and Homeland Security meeting of this session. I'm going to call House Resolution 1126. Representative Evans, if you'll come forward and present that, please.
Good morning. Thank you, Mr. Chairman, members of the committee, including my new best friend, Chairman Alan Powell. Good to be with you this morning. Trying to make this as painless as possible, right? This is House Resolution 1126. It's LC 393420. This resolution came about for two reasons. First, and it's no surprise probably to anybody in this room, that the city of Atlanta has had a problem over the last little bit with excessive street racing and revved engines and mufflers and noise coming through and disturbing the peace. And we get a lot of calls about that. The thought was, could we somehow set a decibel limit? And then if we did, could we use noise detection devices to help police catch those folks? That was brought to me through some city council members who are here to talk to you as well. Then secondly, we know throughout the state that we now have a lot of these security cameras. They're not necessarily government cameras. They're not necessarily speed detection devices. They're just cameras that happen to be on businesses and streets throughout our state. And they can sometimes pick up license tag numbers and help police catch the bad guys. And the thought was brought to me by a constituent, well, why don't we also do like some other states and put the license tag in the front of the car so we have a better chance for those identifying pieces of information to be picked up so that we can catch people that would have done us harm and that we're trying to bring forward. So I asked Legislative Council to draw up bills in that regard and found out, like a lot of things, that it's very complicated. And so that's what leads us to this study committee. Can we or should we set a decibel limit for noise for mufflers? And then can we and should we allow municipalities and counties to use noise detection cameras? I want to be very clear. I'm not looking to provide or create problems or start arresting farmers for really loud tractor noise when they happen to be on the roadways. Not looking to punish, my Uncle Joe who's, down on his luck and can't get his muffler fixed. But I think that if good minds come together, that we can figure out where is that line between, just a mechanical problem versus an intentional setting of a muffler to be loud and participate in the street noise, and then providing our law enforcement the tools that they need to catch them. And then should we look at this front-facing license tag like we know some other states have? Do we think that would help us? And part of the thing I want us to look at and make sure we're not causing unnecessary problems is what's the added cost to this for both the state and for the people? So all of that leads us to what I hope will be a study committee to look at these things, and happy to stand for questions and appreciate your favorable consideration otherwise.
I'm going to say I'm going to be no on the front tag because I like my old 96 Rock tag on my Blazer. And if I could get a personalized 96 Rock front tag, I might go for that, but I'm just stating.
I'll co-sign that. We can do that.
Okay. I'm just being a realist here with you this morning, okay? Number 25.
Thank you, Mr. Chairman. Also, I'd like for you to include the colored lights. This has started presenting a problem down in my area with these big pickup trucks come up behind you, and they've got blue lights. And I don't know if it's the police trying to pull me over or one of the rednecks down there. I don't know who it is, but I think that needs to be included also. But I think your idea is very good, and I appreciate you bringing this. Thank you.
Thank you so much.
Any other questions at this time? yes, I do applaud you for bringing this to us. That study committee, or the committee hearings that we had over the summer to talk about the crime and raise some awareness on some of the things that were going on in the Metro Atlanta area. And I'll have to commend the new mayor, Mayor Dickens. He's done a lot in a brief period of time to make sure that the people of the city of Atlanta and the state of Georgia know that he's serious about changing some of the cultures where crime is concerned. And my hats are off to him. So
Thank you for those comments, and I think this is a great chance for us to continue to say this is a partnership between the city and the state, and let's work together to find solutions. And with, if it's appropriate, Mr. Chairman, I did want to let you know, and I think they signed up, that Atlanta City Council President Doug Shipman and Atlanta City Councilman Amir Faroki are both with us to speak to the resolution very briefly if there's an opportunity.
were they here during the subcommittee also?
They were not.
Okay, yeah, well, if you'll briefly, if you'll come up at this time. Brevity is your friend. Yeah, and our friend.
Well, good morning. I appreciate the opportunity to briefly speak. My name is Doug Shipman. I'm the newly elected president of the Atlanta City Council. My colleague Amir Faroki is here as well, who sponsored a resolution at the City Council supporting this study group. I would simply say that as a newly elected city official, as well as Mayor Dickens, as well as 8 new members of the Atlanta City Council, this election cycle, the number one issue was public safety. And when we talked about public safety, issues of street racing, issues of noise often came up on porches and in town hall meetings. And so I very much appreciate the consideration for a study group that would thoughtfully look at a lot of different options and ideas. I hope it's not just limited to what we've talked about. I think we should work through what is possible and what makes sense, because I think that this is really an opportunity for us to continue to show that we are serious about public safety and that we are also serious about the perception of crime. Because the other thing that loud racing does is that it makes people not want to go out, makes people not want to dine on the sidewalk, makes them not want to walk around, and that makes everybody less safe. And so I really appreciate the consideration of this and look forward to the work if it is passed.
Thank you, Chairman and committee members. I'm Amir Faroki. I represent downtown and midtown here in the city. I'm also a owner of a small nascent olive farm in Johnson County outside of Adrian. And in both places, I will hear loud exhaust. This is really, in many respects, a statewide issue. But I can't tell you the number of emails I get from mothers whose kids get woken up at night, meetings that get disrupted. This has been for my wife every day outside our house. And we have worked with APD, Atlanta Police, to enforce a state ordinance on loud exhaust that exists. It's on the books. They have issued hundreds, if not thousands, of tickets. I asked for the update every few months, and they're writing tickets, but it's not having the impact because, frankly, it's, you know, you can't spend all day writing tickets for this type of thing. And oftentimes when someone hears it, a minute later they're in another part of town. So this is a technology that Knoxville is piloting right now, and it caught my attention, so we introduced this resolution to see if the state would let us try something at the local level. And so I appreciate y'all's consideration of a study committee, and look forward to working with y'all.
Thank you. Yeah. One more question, number 22.
Oh, yeah, I was actually going to ask them a question if they.
Okay, I have a question for you.
Thank you, Mr. Chairman. Sorry to make you sit back down. So when you're talking about the street racing, and I don't understand the ordinances in Atlanta, so I just get to come in for 3 months out of the year. So is it not true that you are not able, your officers in the Atlanta area are not able to chase? I'm learning this through all of this streetcar stuff.
So Atlanta Police allows chases in pursuit of violent felonies in progress or a threatened violent felony. There are certain parts of town where you tend to see it anyway, but we have a very limited chase policy where we oftentimes rely on the state patrol. Now, I will say this issue on loud exhaust isn't always when there's a car that's racing. It could be a car driving at 35 miles an hour down the street. Just the modified muffler allows for such a loud
But as long
noise.
as I go faster than you, I'm okay. In Atlanta, you can't
Yeah.
follow me even if you're coming after a loud exhaust. Is that right? You cannot chase me.
That's Atlanta's police internal policy right now, yes. It's
Is-
not an ordinance by the city council or the mayor, yeah.
But
So
what
what,
you,
I'm sorry then, oh yeah, please.
go ahead.
So and again, I don't understand, but so whose ordinance is that? Or how does that exist?
It's an internal City of Atlanta police policy that the police chief, the previous police chief put it in place, and this current police chief has modified it to allow for chases in certain instances. But it's not through city
Okay,
council action.
okay. Thank you.
Thank you. Yeah, I want to give kudos to the elite crime fighting unit that's been patrolling in Atlanta and busting up a lot of crime and arresting a lot of people. And if those of you who aren't familiar with that, that acronym is GSP. That stands for Georgia State Patrol. And we're very thankful for that crime fighting unit in the metro area right now. Thank you for your support. Representative Evans, you have anything you want to add to this? Okay. If this does come to fruition, I would hopefully like to include this committee in maybe one or two of those hearings, just maybe as a sidebar to your study committee. I don't know that we want to be involved in all of them, but I think it would be
911, the dispatcher was either not able, because of lack of training, to provide the necessary instructions over the phone, or they were prohibited by their department policy from doing it. As you heard, there were, I think, approximately 35 of these types of emergencies at Hartsfield Airport within the last 2 years. And until recently, their policy had prohibited any of their dispatchers, even those with the training, from providing this type of information to a loved one who was calling in and seeking emergency for someone who collapsed in one of the area parking lots or on the property of the airport, resulting in the death of some. So what we as law enforcement officers understand is that our lifeline, as we are on the street, is that dispatcher back at the dispatch center. And what we have to understand is that is the same lifeline that our citizens depend on when they pick up their telephones and they hit those three numbers, that their hope is that the individual that picks up that phone on the other end will give them the information they need, either to save their loved one's life or at least get the resources there as quickly as possible to do that. And so what this bill right here does, and Mr. Chair, I do apologize, I'm reading off of LC 393469S. I'm hoping that it has the date correction, because we did correct the date. And the reason we corrected the date is in conjunction with working with Director Wigington at Georgia Public Safety Training Center, the opportunity for them, which they have a mock 911 center on campus, but to give us the opportunity to make sure that they are fully funded and able to carry out this project. They do it around the state to some degree now, but this right here would bring in the others.
okay. Any questions for the author of the bill? Number 10. Who is that?
That's me, Mr. Chairman.
My
Thank you,
good
Mr.
friend
Chairman.
from the coast. Go ahead.
Yeah, Senator, I just want to tell you, I support this measure absolutely, and I just want to emphasize it. You know, we're talking about, there's already basic training required. We're talking about emergency communications officers. So it seems to me that this should be fundamental. I'm in an industry where we, caregivers, we hire caregivers by the thousands, and even caregivers going in and out of homes, they have to have basic CPR, because this is fundamental to their mission, and it seems like it's fundamental to this mission as well, and this seems to be very commonsensical to me. So I'm very supportive.
Thank you, sir. I appreciate that. And in your industry that no longer do we do mouth to mouth, and many of our citizens around the state do not realize that. So they could attempt to do things that are counterproductive, and this type of resource solves that problem. Thank you so much.
Representative Neal.
Not really a statement. At the appropriate time, I move do pass.
We'll recognize you for a motion at this time. Is there a second? Second. All those in favor, say aye.
Aye.
All those opposed, like sign. Thank you. Won't you just sit tight right there, Senator, and we'll let you present SB 504.
Yes, sir. Another simple piece of legislation with some adjustments. And I want to thank the subcommittee and thank Chairman Powell for an amendment that was made to the bill, and I'm reading off of LC 393474S as in Sierra. And the line that was amended is line 53, where it's, line 52 to 53, where it says, if the defendant has been judicially placed into an accountability court as defined in Code Section 15-1-18. And what this legislation here simply does is it takes the felonies in the state of Georgia and makes each felony in the state of Georgia a bail-restricted offense. We did this 2 years ago with violent felonies. And what we continued to find out, we were continuing getting lists where judges were either confused or failing to follow the ministerial directions within the law of requiring individuals to post bail before being released. So we continued having individuals charged with domestic violent cases and other cases being released without posting bond. So we looked at several cases we wanted to bring, or several types of charges we wanted to bring under here. And there were very few, but once you start looking throughout Georgia Code, you find there are a lot of felonies within Georgia Code. But what you do find in there is you find these rare hen's teeth within the Georgia Code that, as I mentioned in subcommittee, we have not had any major arrests in people mislabeling Vidalia onions. We have not had any major arrests in individuals setting up their own funeral homes, chiropractors practicing without licenses, or people selling cotton under the wrong permit, and individuals failing to maintain livestock records. So the felonies that this would primarily focus on are those felonies that we see coming in and out. The latest jail report shows that we have a few of our smaller jails that might be overpopulated, not by much, a few percentage points. And if you counter in the number of inmates being housed there that actually belong to the state and should have been already picked up and transferred to Jackson for classification and integration into the Department of Corrections, you find that our jail population is actually better than it has been. And any jail population right now, based on the records that I looked at yesterday, is primarily on the slowdown in the court system caused by the pandemic. And our judges are back up and running at full speed, and so everything seems to be coming copacetic. So all this is doing is when somebody comes in on a felony charge, to make bright lines for the judges, they can set bonds, like we said before, at $10, $10,000, or $100,000 based on the criminal history and the types of crimes that the individual's being arrested or charged with. And with that, Mr. Chairman, again, thank you for the very thorough subcommittee vetting, and I would welcome any questions from the full committee.
To my friend from the coast, Representative or Chairman Petrie.
Thank you again, Mr. Chairman, and Senator, thank you. I have spent much of my time here. I came up here dealing with violent crime, and one of the things I've diligently studied crime and dealt with a great deal as it relates to parole reform in my earlier years here. But I will tell you that is it not true that overwhelmingly the people that commit crimes in our community, particularly violent crimes, are already felons, and they commit crime, the same small subset of our population commit crimes over and over and over and over again. Is that not true?
That is absolutely true, sir.
It is the truest thing that will be said in here today. That is correct, and I'm very supportive of this measure, sir.
Thank you, sir.
This is how we protect our people.
Thank you, sir.
Let's see, to my friend Chairman Powell.
Thank you. I don't know about that being the truest thing that's going to be said, because I think there's going to be a lot of true things said today. I want to commend you for this, but I also have a footnote that I would like to add to this. By virtue of this bill coming before in the subcommittee, it rehashed a lot of issues that need to be dealt with our courts and the bonding system. A couple of things that I would like to make some final recommendations on. You know, I had my comments to this was that when somebody is arrested, a bond is not a fine. A bond is the only way to ensure that if they're going to be bonded out, that they have a path to get them back in there to court. Now, that being said, as we had looked and heard during the subcommittee hearing, you know, I knew there were a lot of felonies that were still on the books that are antiquated. Well, quite frankly, we have so many folks up here that have nothing better to do than create mischief. They need to be looking at this list of 100 or so felonies that are antiquated so that they can clean the books to maybe help the criminal justice system a little bit better. Secondly, we know that a lot of people, we heard some descriptions of some outrageous cases. We know that professional law enforcement officers do their job, then they go forward to the DAs and to the judges for the bonding issue. There's some things that bonds are set that are, again, outrageous. We know that in the real world, that if someone is arrested, it has a physical ailment. The sheriffs want them out of their jails. They want them out because they don't want to have to pay for the medical expense. And I agree with that. And then you have some other issues, like one was talked about a lady who lost her children because there was some kind of apparent drugs or something that apparently showed up. It wasn't. Well, you know, there's nothing true to our system at some times. But I had made my comments to that these folks need to understand, as do a message needs to go to the DAs and to the judiciary, that when somebody is arrested, they need to scrutinize those arrests to be sure that they're valid, not just to lock them up so that they're sitting in jail awaiting trial, because you're still supposedly innocent until proven guilty in this state and in this nation. Now, if they're at risk of flight, I understand the judge has that duty to set whatever appropriate bail would be or bond would be. But there needs to be a clear message to both the proponents and the opponents of this, that DAs and judges are the ones who negotiate to set whatever the bond may be. And the bond needs to be consummate to whatever that offense and the circumstances of that offense is. That being said, I'd like to make a recommendation to you, because I know what a strong law and order guy you are. There needs to be a resolution hastily dropped, probably in both houses, because I'm not sure the House and the Senate, after what we're seeing this session, can get along on much anything. But I would encourage the powers that be and yourself that there be a resolution dropped in so that there could be work done before the next legislative session to clean the books on unnecessary and antiquated felonies, to get it away so there's not a stacking of charges, as we call it in the real world. And also, there needs to be discussion with these judges. You know, a judge can set a bond, and that bond is not limited of whatever the amount may be. So instead of going unnecessarily setting a bond on some questionable issue or a nonviolent issue, then maybe that judge needs to use that judicial discretion to set that bond in an appropriate manner so that person is not held into custody for the length of a duration to get to a trial. And those are the issues that I'd like to bring up to this. So I understand what the opponents of this bill are, but at the end of the day, we have one issue on the bonds. Bonds are there to be sure that those who are accused show back up in court. If not, we will have a continuously breakdown of our justice system. And I thank you.
Thank you, Mr. Chairman, and I do want to emphasize I agree with you that the entire judicial system, along with the criminal justice system, needs to work together to make sure that we are arresting the correct people, and that we are not housing individuals who are whose lives we're doing more damage to by housing them than by allowing them to be out in the community. Throughout my law enforcement career, once I moved up in certain positions, I had the unfortunate task of shutting down bonding companies who did not act in good faith, foreclosing on bonding companies who failed to manage themselves financially sound and according to state law. I do think that there are way too many felonies on the Georgia books, especially those that you're discussing, those that are antiquated. And at the same time, we do have the JQC as an oversight group of those judges should they misconduct or conduct themselves in an unprofessional manner. And I do know that in most county jails throughout the state, the judges go ahead and pre-assess bonds on most charges. So when an individual is brought into jail on a felony, the sheriff's office that runs that jail is able to pick up a notebook, look, see what that charge is, see what that bond is, and expedite that individual's discharged from jail. So these individuals aren't having to sit there and wait for a judge to make a phone call and do this. So I know there are a lot of things in place to expedite the due process, but without a doubt, you're right, it's a very cumbersome system. And I think even though, someone in your leadership position sees the dysfunction within the General Assembly, a lowly state senator like myself, I see a lot of cooperation on both sides, and I'll be more than happy to work with you and drop that resolution to get the ball rolling on cleaning the codes up.
Thanks for bringing
Thank you, Mr. Chairman.
Floor Leader Lott.
Thank you, Mr. Chairman. So, not my area. This is not my area. I'm one of the people on this committee that learn as I go. So I do have some questions about this legislation. You, to be clear, bail restricted offense means that they must stay in jail?
No, ma'am.
Okay,
It
please
means
help
they
me.
must post bail.
They must post bail. So this just means what he was talking about, the bonding out.
Yes, ma'am.
So there must be a cash bond required. That's what that means.
There must be cash or some asset. Yes, ma'am. Not all are necessarily cash. Some put up property, some put up other assets. It cannot be an asset that's transferable. So in other words, it cannot be a vehicle or anything somebody can hop in, crank up, and drive away in. But they can put up certain assets. Most of the time, it's 10 to 15% of what the total bond is. And once the individual follows through the case, that is refunded back to the individual, less any fees that the bonding company may have, which those fees are regulated under Title 17 to not be exorbitant.
Okay, excellent. Thank you for clarifying that for me. I didn't understand. Also, there was a statement made, you were referring to actually, and I think your quote was expedite due process.
Yes, ma'am.
What is the meaning of that? What is the understanding?
Expediting due process is to make sure the system runs as fast as possible. And so, when an individual, whether they're arrested for DUI or whether they're arrested for murder, there are certain benchmarks that have to be hit as far as first hearings, indictments, and if they want to plead guilty and other things. And so, as quick as we can get them into jail, processed, out of jail, if they want to retain an attorney, if they want to represent themselves, all of these things happen so much faster and so much smoother if we don't have problems at the beginning. And so judges understanding, like the problem we had here in the metro Atlanta area where we had judges releasing violent individuals back out, these individuals were reoffending within a day. And so basically what they were doing is they were stacking violent charges, and we had some that would get out on a signature bond on one day, go out, commit another violent felony, and I'm talking about shooting in apartment complexes and things like that, being rearrested and then being re-released on another signature bond. And so what we're trying to do here is make the lines bright. Everybody that comes into jail that is charged with a felony, the process will be smooth. They'll go in, they'll know what the bond is, they'll post bond, they'll get out, depending on the type of charge. And when I said DUI a while ago, it would take a third DUI for it to be a felony. But they would be able to retain counsel, do whatever they need to do, go to work, do everything they need to do without delay.
So, further question,
Go
Mr.
ahead.
Chairman, are
Go
we
ahead.
okay? So they, but what in this legislation has anything to do with us ensuring that their process is expedited?
By the fact that we're identifying all felonies as bail-restricted offenses.
Okay.
So that is known from the beat officer up to the Chief Justice of the Georgia Supreme Court.
Okay, and so one more thing. So there is, there's actually, I have two things. So one, I think there was an article in the Atlanta Journal-Constitution or somewhere yesterday. It was forwarded to me yesterday by someone that did make the statement in reference to what Chairman Powell was talking about. And I don't have the article in front of me, but if I remember it, it said 40% of the crimes in Atlanta are committed by 1,000 people, the same people over and over, and it basically said 1,000 people. And so we are seeing that, right? That these are
Yes,
repeat
ma'am.
offenders. And then lastly, there's a letter on my desk, and it is in opposition to this legislation. And I just recognized that the district attorney from Augusta Judicial Circuit happens to be on this. And just recently, again, I don't know the circumstances in the case, So I can't speak to that, but I know that we have had 2 gang-related folks released, and subsequently 2 murders, one of a child, recently from them within 2 months of them being released. And is that the kind of thing that we're trying to stop from happening with this?
That's absolutely what we're trying to stop. And what we're all trying to stop is if you go around and poll the prosecutors throughout the state, you're going to get quite a few who like this, and you're going to get some who don't. The issues we have within our judicial system is here of late, over the past 10 or 15 years, we've seen it here in Georgia, we've experienced it in New York, and then there's been a recent recall in San Francisco. What we're finding is a lot of activists who are infiltrating our criminal justice system, and instead of looking at the law and following the law, they're using politics, which is another reason why I support nonpartisan races and district attorneys' races, sheriff's races, and all this other stuff. The last place we need politics is in the criminal justice system. I'm very proud to be a part of that system, and I can say for a fact that the people I serve with, we see Title 16, we see Title 40. We don't see gender, we don't see race, we don't see faith or any of that. And sadly, within the criminal justice system, there are activists, and while I respect their ability to speak out, I don't think it should ever be allowed to impact the safety of the people that live in the state of Georgia.
Thank you very much for your
Yes,
time.
ma'am. Thank you.
Number 13, Representative Evans.
Thank you, Chairman. Thank you, Senator. So I was not on the subcommittee that studied this issue. So I just want to know, before the pandemic, what were the results? I mean, of judges releasing these violent offenders again and again and again? Did you see that pattern before the pandemic?
Yes, ma'am.
Could you?
Yes, ma'am. And that was one of the things we started looking at, as has been mentioned, recidivists and other individuals. And what we were finding in some of the cases, and there was a recent case here in Fulton County where I think the police chief did a news conference week before last where 20 individuals were arrested, and those 20 individuals were responsible for over 500 crimes amongst themselves. And that has been the pattern probably for the past, I would say easily, probably the past 8 to 9 years, where individuals are accountability courts were a great solution to get individuals into there, get the help they need while they're still a part of the criminal justice system. But what some judges were doing were releasing people back into the community quickly prior to full vetting of the individual's criminal history and the particular crime that they were charged with at that time. And what that was resulting in is the individuals going out and reoffending. And at the same time, these were individuals that they had limited information on, and once you post a bond, again, whether it's a $10 bond or $10,000 bond, a lot of information, a lot of data points are derived from that individual as far as residence, occupation, things of that nature, that is used to keep track of the individual so that they stay a part of the criminal justice system until their case has been adjudicated and due process executed.
One more question, Chairman, a follow-up?
Go ahead.
Okay, thank you. So in the change, and so if they're going to an accountability court, then they do not have to post bond, is that right?
That's correct. If they go in and it's obvious that it is a substance abuse issue, then the judge can send them to drug court, drug accountability court. If they're a veteran, they could go to a veterans court. In mental health, the same way. We established those courts and a couple of others within the Chattahoochee circuit over the last 10 years.
And may I ask a follow-up to that, Senator? So are those courts available throughout the state or just in certain jurisdictions?
I'm not sure. I know going through the budget process that there are a lot of those, but I know where the vast majority of our crimes are committed are in the urban areas, Savannah, Columbus, Macon, Augusta, Atlanta, and I do know that those courts are available in those areas. Mm-hmm. Yes, ma'am.
And then I also, just a final thing, the folks that wrote us this letter have asked us to consider a study committee, and I know Chairman Powell has just made a request for a review of some type of committee to review this list of antiquated felonies. are you amenable to a study committee on this issue and also to address the issue that Chairman Powell brought up as well?
I just came off a study committee where we reviewed the judges that were failing to do this. This past summer, the Standing Public Safety Committee in the Senate held a study committee through the summer where we looked at these types of issues throughout our state. But I'm amicable to any study committee whose focus is on keeping Georgia safe. And so whatever the subject matter may be, which if it touches public safety, I'm supportive of any any study committee that deals with public safety.
Okay, ladies and gentlemen, I'm gonna call the question at this time. This bill having been vetted and heard testimony in subcommittee, do I hear a motion that we approve? Is there a second? Okay. Senate Bill 504, LC 393474S. All those in favor, please say aye. Aye. All those opposed, like sign. No. Ayes clearly have it, and this bill will move on to rules. Thank you very much, Senator.
Thank you, Mr. Chairman. Thank you, committee.
Senate Bill 259 will now be brought before us. Mr. Chairman, Chairmans,
So
the
good to
floor is
be with
yours.
y'all today. As y'all had heard in this committee a week or so ago, when Senator Mullis was here, we had made some changes to this bill, went to rules, and then it came back because we saw that we needed to do a little bit more work on a couple of the issues in here. If you may remember, Section 1, this deals with a problem that we've had for the last 7 or 8 years. When we did the concealed weapon carry bill that was expanded 6, 7, 8 years ago, whenever it was, Governor Deal was the governor. And Governor Deal was adamant that he did not think that churches should be treated as private property. The problem over the last several years that's been created with this has been that we have churches who could not authorize certain people to carry a firearm. And all of this is because of the day of the open shooters. The churches were basically open game to criminal elements that wanted to come in and do these open shootings. And a lot of the churches, and mostly the smaller churches, they were having a very major problem with this because they couldn't allow folks, and they wanted this to change. So this is what we've done in this. We've moved ahead and we've started treating houses of worship and places of worship the way they should, as private property.
Right.
Not as any specified classification, but treat them just the way they are. Let them make their own decisions about who they want to allow to carry a firearm in their church. Section 2. This was the change of the language to allow the probate judges, because remember, even though we have passed constitutional carry, we still have a concealed weapon permit that I encourage those people who believe in their Second Amendment rights, and if they're traveling or whatever, to keep that in force, because the concealed weapon permit does a couple of things. One is it is good for the reciprocity that they may encounter in other states who don't recognize constitutional carry, but secondly, it also gives them the ability when they go to a federally licensed firearm dealership, so that they can then have already been background checked. What this does, this allows the probate judges in this state, who are the authorizing agency to issue permits, to implement an online system of applications, and also for them to receive the renewal applications by first-class mail. Moving to Section 3. This was the language that deals with being able to use your firearm and to discharge a firearm. What we've said in this language is that basically that this will not circumvent any zoning ordinances. There were concerns that we were going to use, that this was being used to circumvent municipal or county zoning ordinances. That does not. what it says is that you may discharge your firearm. And we picked 10 acres was the acreage that was picked because of people's hunting rights and sporting rights. If you move to Section 4, this dealt with the local governments disposing of firearms. Under the current law, they're supposed to dispose of these firearms. But we have a lot of the jurisdictions that are holding these firearms, amassing these firearms, and we know what happens in government bureaucracy at times. The more these weapons are held and the more stockpile they get, then sometimes these weapons disappear. And they need to be sold as prescribed by law. And that's what we're putting into this, and what we've said in this is that they will discharge the duties of law. And if that is, and I believe that they will have a sale every 12 months or whenever, and when they get an inventory of 5 or more of these weapons. A lot of these, or if there's also prescription in there, if these are not legal weapons, then they're destroyed. Or if these weapons are not, or say that they're dangerous weapons, say they're just non-functional, they can be destroyed. But if it is a good weapon, then they've got to be auctioned off. And to say go a bit further, don't think that these can be auctioned off to just anybody. These weapons have to go through a federally licensed firearms dealer. So for those of y'all who might think that we're fixing to say they got to be auctioned off to just any willy-nilly on the street, no. It has to go through the same federal process that they're eligible to be able to buy these weapons.
And then, Mr. Chairman, if I may, if we're requiring that they be sold to a licensed firearm dealer, before those guns are sold to someone else, they have to clear a background check if they're
That's
purchasing
exactly
from
right.
a firearms dealer. Is that correct?
That's exactly correct.
So that's another level of transparency and safety there.
Absolutely. Section 5 deals with the restoration of rights. This is where we have made this, and Section 6 is where we've had to make some changes. You know, there's nothing, and I don't think anybody could disagree, but there's nothing more important than a person's constitutional rights. And under the laws of dealing with firearms, if you've been adjudicated mentally ill or for whatever the purpose may be, then we have stepped in a matter of public safety and good to prohibit someone that's been adjudicated with a mental illness. But sometimes that mental illness is not always, does not always stick forever. And what we've done, and I'll give you an example of that. I had a young man up in northeast Georgia that reached out to me that when he was a young man, I think of probably 18 or so, I really don't know the age, but he had a physical ailment. Don't know what the physical ailment was, didn't ask, but I took him at his word to that. But because of that physical ailment, he was adjudicated of having a mental health issue. 10, 15 years after the fact, once his health condition was remedied, the mental illness went away. But still, under our laws and our system, he could not own a weapon, couldn't exercise his Second Amendment constitutional right. And this sets forth the methodology so that he can petition to the courts, show evidence, and move forward. And that would be left up to the judges and the prosecutors, or in the prosecuting being told if a family member wanted to come forth to give testimony, then they could do it. So Section 5 deals with restoration of rights in the legislative process, and I think Chairman Jaspers wants to address that.
Yes, sir, Mr. Chairman. Thank you, Chairman Powell. This is one of those that we worked on a number of years ago, and I think we've had better information to try to come up with a really good way of restoration of rights. If you look on line 201, we've had a number of members over the years that have had to strike the very language we're striking here right now. And it's really irrelevant that strike is there, so we're getting it out too. That language is in there, so we're taking that out. Because if you're declared involuntarily committed or involuntarily hospitalized, that information goes to NCIC. You know, it does go into the Georgia crime, but it goes further. And this prohibition is a federal prohibition. And so you see below it in lines 206 through a lot, a process by which someone that Chairman Powell described can get their rights back. And so if you look at what we did a couple of weeks or last week, you see we've worked on it a lot to try to define and make it better and clearer. One key change that we made was that, let's say if you go to Superior Court, they turn you down. You're going to have to stay out for 10 years to begin with, but, 5 years, excuse me. And then if you're turned down, you can't come back to the court for another 3 years. We didn't have any of that language in there, which would have really clogged Superior Courts up. They've got a tough enough time now dealing with what they're doing. So it's, once you're have this happen to you, 5 years out, and then if they turn you down again, 3 years again, and that 3 years goes on. If you see, it's just a lot of detail to be very prescriptive on how this works. And sections 6 and 7 are just referencing back to federal code. And we get this language from the feds on how to do this, and that's why you see it in line 208, the federal section. There is a grant process for states that do this if we follow their rules, and that's what we're trying to to qualify for by putting that federal language in there.
Next, Section 8, after we've gone through the process of restoration. Section 8 deals with the state of an emergency. This has been a source of contention for years about the executive power of the governor, that he, during a state of an emergency, that they can seize weapons, they can close stores, they can basically do any and all things. This removes those prohibitions, so that you are then, in fact, that the citizens of this state are then being able to exercise their right without a state of an emergency impending that.
Just to follow up, Mr. Chairman, I just want to add one thing to that. Now, they could close them if they close all stores. That's the key thing in this, and the governor's office has agreed to this language.
So can't pick and choose. If you're gonna close one, you gotta close them all.
Exactly.
Okay.
And probably the only way that would happen if we turned into a situation such as what's going on overseas right now. And that, ladies and gentlemen, is the gist of this substitute to Senator Chairman Mullis's bill. We've been working on this for several years. We're moving forward with this. This isn't. This is something that is very important to the rights of Georgians. Cleans up the system. I'm not sure that you're taking testimony, but I can tell you that there are a couple of issues were contentious to some folks. That's the reason we have spent more time going back, because as a lot of y'all know, that some of us, Chairman Jaspers, especially myself, we don't look at passing legislation that hasn't been perfected, and we do the absolutely best. But we are talking about one subject matter. It's absolutely imperative that we do it right, because there's always some other factor that can come into play. And the church carry, for instance, a lot of people turn their nose up at it. I know that we're probably not taking testimony today, but there's a gentleman who represents, I believe, the Georgia Baptist, that the Georgia Baptists support this. And I think probably for more reasons than one, that anytime the government interferes with religion or our religious institutions, I don't think anything good comes of that. The churches want to be treated as what they are, and that's private business or private property.
Thank you, Mr. Chairman. I've got a question for you. In the way the language is written currently in this substitute, would a church be required to post a sign or a policy in front of their sanctuary or on their grounds?
You know, I've heard that said a lot of times by some of the people in this, but I don't believe so. If they're treated as private property,
Right.
they can determine
Right.
who carries a weapon on their property. If they feel it's inclined to do so, then they can put up a sign if they want to.
Right.
If they see someone carrying a weapon that they have concerns about, they can ask that person to leave, and they'll be treated as trespassers if they don't.
Yeah, I just want to add, Mr. Chairman, just as similarly as a no shoes, no shirt, no service, the place of business still has to enforce that through, as Chairman Powell says, private property and a trespass. They have to ask them, decline, then they can pursue it.
I try not to go in places that have a policy like that, you know?
Yeah, I know.
Any questions at this time for Chairman Powell or Chairman Jaspers? Representative Neal.
Yes, thank you. Section two, section 3, 107, starting at line 107. My question is, just confirming, I guess, yea or nay, if you can already discharge based on 1611-104 on your own property. I'm trying to understand the difference between that code section versus what we're adding here with the 10 acres. If somebody could advise.
Well, I think legal counsel can cite that code section, but the purpose of the 10 acres is we have people that's been brought to us over the years, that we have people who have acreage that would like to hunt on that property. But they're being told by their city or their county, no, you're restricted, no discharging of the firearms. 10 acres is a pretty good piece of property.
Okay, and confirm, I think you made a reference to it before. Can other counties outline their acreage being more or less than this, absent of this bill? 'Cause I think
This says 10 acres or more.
No, absent of this bill, can the counties already outline their own acreage reference?
I think the almighty power of GMA and ACCG, they want to do anything they want to do.
Okay, because I say, for instance, I think like Newton County has like 2 acres, and like this would change the 2 to like a 10, and I want to
Well,
kind of.
no, it wouldn't do that. If they say that you can
Do it with 2.
shoot on more than, you got to have more than 2. We're saying that 10 acres or more.
Okay.
Representative Jenkins, is that right?
Yes.
Okay.
And I just want to speak to that as well. I appreciate y'all including this, having been with my family, having 60 acres of land that got annexed into a city, and we lost the ability to shoot and hunt on it. And I've known many other people like that. And this speaks to another issue with our exploding urban deer population, you know, and the motor vehicle accidents associated with that. So I think that'll really help us control that problem as well. So I do appreciate that.
Thank you for your comments, and you're absolutely right.
Okay. Any more questions for the author of the bill? Would we be recognized for a motion at this time if someone would like to make it? Okay. Motion is made and seconded to do pass Senate Bill, the substitute Senate Bill 259 LC 393481S. All those in favor, please say aye. Aye. All those opposed, like sign. No. Okay, the ayes have it. Thank you, Mr. Chairman.
Thank you, Mr. Chairman.
Mr. Chairman, I just had one thought there. When I first sat down in the folder we got, I saw this from the Metro Chamber, and I said, 257. I thought, well, that's our bill. Metro Chamber's for this?
Well, you know, we can only have so much unity and with Representative Evans and Chairman Powell on the same page. That's asking a lot there. All right, we're going to hear Senate Bill 257 at this time. It is not on the agenda, but it is in your packet. We heard this in subcommittee, I believe it was last week, 2 weeks ago we heard it in subcommittee, and there were some changes that were requested to be made. So we're working off of the substitute Senate Bill 257, LC 490966S. Is that what you're presenting here today?
Yes.
Okay. Does all the members of the committee have that substitute?
Yes.
Okay. All right. Please go right ahead, present the bill.
Good morning. Thank you, Mr. Chairman, and to the members of the committee. I'm excited to see some friends, and I'm making new friends as I'm a former member of the House. Senate Bill 257 is an expansion of Senate Bill 288, which received unanimous and bipartisan support, supported by the Georgia Justice Project and the Metro Atlanta Chamber. So thank you, Chairman Jaspers, for making mention of that. This bill allows for the restriction and sealing of records for some misdemeanors and some felonies. This bill has provided some minor cleanup changes, clarifications, and expansions of the work that we did together in 2020 on Senate Bill 288. We worked with both the GBI and PAC on relevant portions of the bill, and the business community remains very supportive of our efforts. These changes allow for the restricting and sealing of records of those who have are human sex trafficking survivors, as well as those who have already been pardoned by the Board of Pardon and Paroles, which is an arduous process that takes a very long time. So if they've made it through that process, then this will allow for them the opportunity, as they still have to petition the courts for that sealing and restricting. But this bill is also an opportunity for going back to work, going back to school, receiving housing. It reduces recidivism. It hopefully will reduce some of the unemployment and cuts back on the millions of dollars that we spend on recidivism. And it also strengthens the economy. So as I stated before, the business community is still in support of this bill. So I also brought Wade with me to help with any input that he has based on the Georgia Justice Project.
Thank you, Senator Anderson. Thank you, Mr. Chairman and members of the committee. Thank you. My name is Wade Askew. I'm a supervising attorney at Georgia Justice Project. And so as Senator Anderson explained, 2 years ago, SB 288 passed with bipartisan support. It passed unanimously through both chambers. 257 only focuses on some minor cleanup issues that we've seen in our practice day to day with folks, just trying to give full effect to the legislature's intent in 288. So some of the things that Senator Anderson described in terms of folks being eligible for relief, that's already existing law. 257 just is not a significant change as to eligibility for restriction and sealing. Instead, it just focuses on a couple of discrete issues that we've seen in the implementation of the law. And so since we met with the subcommittee, we've received and gained some feedback from agencies and stakeholders, and that's resulted in the substitute that you see today. So specifically what we've done since we last saw some of you is we took out automatic restriction of offenses if a offense has been pardoned by the Board of Pardons and Paroles. So a previous version of this bill that you had seen said that if a offense was pardoned, then automatically there would be a notification for restriction. That has been removed. That is no longer the case. So the current procedure, as was created under 288, of if you get a pardon, then you can go petition a court who would confirm your eligibility or ineligibility for restriction and sealing. That procedure is maintained. So that's the change that you see today. Otherwise, it's the same bill. It's the same bill that passed with overwhelming bipartisan support in the Senate. It is the same bill that retains the support of the business community and specifically Georgia Chamber of Commerce and the Metro Chamber. So I'm happy to go through any particular provisions of the bill, answer any questions that any of you may have.
Any questions from members of the committee? I do have one question for you. On lines 37 through 39, and it says, if the court finds that the criteria for such petitions are met, the court shall grant an order restricting such criminal history record information. If we struck shall and substituted may there, would that really hurt the intent of the bill, or would it allow for some discretion by the court?
Striking shall and replacing with may would allow for discretion by the court. The intent of the bill was to say that the as Senator Anderson mentioned, that the bar for receiving a pardon is very, very high. It's typically a year-long process, involves interviews, a large amount of evidence to be provided to the board. I believe in 2021, 444 pardons were granted. I might be slightly off, but we're talking ballpark 400 or 500 a year. And so the idea was to say, if a pardon's been granted, then we still want a judge to make sure that eligibility criteria, be a final gatekeeper to say, okay, this was not a serious violent offense or serious sexual offense, because while you can receive a pardon for those things, even if you have received a pardon, you're still not eligible for restriction. Okay. And so judges would still be, and prosecutors as well. This motion would need to be served on prosecutors. So prosecutors and judges can be those final gatekeepers to say, okay, we understand you've passed this high bar to get a pardon, but let's make sure that all the eligibility criteria are still present. And if so, then okay, let's move forward.
So you wouldn't have a problem with us changing that shall to may? You wouldn't have an issue with that?
We would prefer to keep the shall to expedite the process for folks, so that we're just kind of checking on those eligibility criteria. But if that's the pleasure of the committee, we understand that.
It wouldn't be a deal breaker for you then?
Would not be a deal breaker.
Okay. Number 12 down there, is that?
That's me. Thank you, Mr. Chairman. Just as Floor Leader Lott said, we're learning about these things. I'm just curious, does this appeal to the court go back to the originating court that tried the offense, or can it be where you live right now?
Thank you. It is the original court that heard the offense. Okay. So if I have a record any corner of this state, I need to make the effort to go to whichever court okay. adjudicated my original case.
Thank you, Chair.
Number 11, Mr. Chairman.
Thank you. I understand your idea about changing the shall to may. The only concern I'd have with that was that we do know how the courts work, and sometimes they don't always get around to doing what the intent is. This would specify that they will do what they need to do in this change in the recording.
Okay. Number 3.
Thank you, Mr. Chairman. And actually, I was going to say the same thing Chairman Powell said. I agree. It should probably stay the shall.
Okay. All right. What would be the pleasure or desire of the committee? Motion is made and a second to do pass the substitute Senate Bill 257 LC 490966S. All those in favor, please say aye. Aye. All those opposed, like sign. Okay.
Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Chairman and members of the committee.
Thank you.
Did you want me to adjourn immediately?
No, sir. Just there's one more bill there. I hope you'll.
All right. All right, Mr. Chairman.
Oh.
If you'll present your bill, please.
Chairman Mullis had a piece of legislation he sent over, and we took that out and added in another important piece of legislation that needs to pass. I think the Senate took this up this week. But basically what it's doing, where bail bonding companies are concerned, during this pandemic, you have seen that there are a lot of cases that haven't been cleared. And so our friends in the bonding business are faced with a little bit of a dilemma. What we're doing is we're just cutting down the 10% of outstanding bail bond liability to 5%. And saying that their escrow shall not be required to have a deposit in the excess of $1 million. Those cases that are on the books are still pending, and all we're doing is just saying we're going to cut down from 10% to 5% of what their liability is.
Okay.
That's the genesis of the bill.
Very good. Do we have any comments from the members of the committee? Representative Frazier.
Yes, thank you, Mr. Chairman. Mr. Chairman, can you tell me what is the reason for this decrease?
Well,
Again?
because right now, the bail bondsmen are required to post or have in certain situations the form of collateral that is 10% of the current outstanding bail bond liability. And the problem is the court system has seen so many cases that just stopped. Okay, so their liability is increased. It just cuts that figure down to 5%. So in a lot of cases, they're really, they're still on the hook for a lot more, a smaller percentage of a lot more money. Does that make sense to you?
It makes a little sense to me, but however, in small counties, normally, they only have one bail bondsman. So I can understand the increase in cases, and they have to take care of a lot of folks. But like in the metro area, this is bail bonds town here.
Right.
So, but I'm just trying to understand what's the
Well,
decrease? Is it because of the cases?
That's correct.
That's all, I just need clarity.
That's correct.
Is it
Yes,
because
ma'am.
of the number of cases that they have?
That's exactly right. Yes, ma'am.
Okay.
And also too, if you're a bail bondsman, you serve at the pleasure of the sheriff in that county. And if you got a bail bondsman that's not doing things they need to be doing, the sheriff has that right to withdraw that ability. So this doesn't, keep sheriffs from making sure that the people that are bonding folks out of jail are not the folks he wants or she wants.
Okay, that answer your question?
Yes, thank you.
Okay. All right, do we have other members that wish to speak or ask any questions? Okay. All right, I'll ask for a motion then, and I think I've heard one there, if you'll. We have a motion for a do pass. Do we have a second? And we have a second. All right, all those in favor of Senate Bill, substitute to Senate Bill 259, please signify by saying aye. Aye. Those opposed? Okay.
That was Senate Bill
I mean,
277, Mr. Chairman, I'm
250.
sorry.
Sorry. Yeah. Let's do that over to make sure we've got it correct. It's this Senate Bill 277, substitute to Senate Bill 277. Those in favor, say aye. Aye. Those opposed? Okay. The ayes have it. Thank you, sir. And we are adjourned. Alan was saying, do it.